Item number 1.
May I please, Your Lordship? My Lord, the petitioner before Your Lordship is wife of my Lord, respondent, my Lord. And they married, my Lord, in the year 2015. And in the year 2017, my Lord, my Lord, my Lord, the male child was birth, my Lord. And in the year 2018, my Lord, she got one job, my Lord, in the Hailakandi Civil Hospital on contractual basis. Accordingly, my Lord, mutually, my Lord, she was residing at her parental house for the time being, my Lord, and doing job, my Lord. And happily, my Lord, this husband, my Lord, respondent, my Lord, was also cooperating with her, my Lord, staying there. Recently, my Lord, there, my Lord, differences has been, my Lord, developed, my Lord. And suddenly, my Lord, he filed one divorce petition in the Court of Family Court, my Lord, Gauhati, my Lord. And in the, my Lord, the petition, Lordship, kindly will look page 12, annexure 1. In his statement itself, my Lord, reflected that, my Lord, since 2018, my Lord, she is residing there, my Lord, with son, my Lord, and she is doing job in the medical Hailakandi, my Lord. So therefore, my Lord, apart from her convenience, my Lord, with this full-going, my Lord, 8 years old son, my Lord, and job, my Lord. Here in this case, as per the statement, my Lord, the cause of action is also, my Lord, arisen in the Hailakandi before the landed district judge, my Lord, because, my Lord, the allegation is very precise, my Lord. She is not coming from there, my Lord. Therefore, my Lord, this case is filed, my Lord.
Heard Mr. A. Borguya, learned counsel for the petitioner. This petition under section 24 of the Code of Civil Procedure, the petitioner, who happens to be the wife of the respondent, tries for transferring of FC Civil Case number 1636 of 2025 pending before the Court of Learned Principal Judge Family Court number 2, Kamrup and Gauhati, to the Court of Learned District Judge Hailakandi. District Judge Hailakandi. Mr. Borguya, learned counsel for the petitioner, submits that the petitioner and the respondent are husband and wife, and their marriage was solemnized in the year
2015, my Lord.
2015,
2015.
and thereafter they lived together as husband and wife at Hailakandi.
My Lord, initially Gauhati, then since 2018 in
Initially
Hailakandi.
at Hailakandi, and thereafter at initially at Gauhati and thereafter at Hailakandi. But subsequently, marital discord surfaced between them, and the petitioner left for Gauhati, and the respondent left for Gauhati and residing here, and he has instituted FC Civil Case number 1636 of 2025 before the Court of Learned Principal Judge Family Court. Petitioner belongs to which place, or the respondent belongs to which
The
place?
respondent belongs to Kamrup, my Lord, and she belongs to, my Lord, Hailakandi.
Where the case was instituted?
Gauhati.
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 The petition is available with you?
Now,
Copy of
but
this-
now he,
Copy of the petition is available with you?
yes, my Lord.
You see the cause title?
My Lord. First post title, my Lord.
Huh?
First post title.
Yes.
A humble prayer for transferring the FC case number so from the Learned Principal Judge, Family Court, Casa, Silchar, to the Court of Learned District Judge, Hailakandi, my Lord. Oh, sorry, my Lord, it is. My Lord.
Hmm? You delete the other part. On the pair being made by Mr.
In the main term, my Lord, it is okay.
On the pair being made by Mr. Borhuya, learned counsel for the petitioner. The matter stands adjourned to be listed after a week, so as to enable him to file amended cause title. After 1 week.
Fact number 2. Apply.
My lord, the petitioners agreed with the impugned order of the learned civil judge senior division, uh, was dismissed the appeal of the first appeal of the present petitioner. Without considering the documents, those were sought to be adduced as additional evidence before the appellate court. In terms of the direction of this honorable court, passed in CRP IO 28 of 24, which is annexed at annexon 9, operative portion of page 87, my lord.
The suit was for
For recovery of arrears of rent between the parties, issue of defaulter. But actually, the suit is not for defaulter. From the documents, if the annexer 11 be perused, legal notice of the plaintiff side, page 119 of this civil division petition,
119.
119 onwards. Lordship, go to page 120. 120.
Well, let notice go at this is this.
Yes.
Third, Mr. Pal, learned counsel for the petitioner. In this petition under article under section 115 the Code of Civil Procedure, the petitioner has challenged the judgment and order dated 6/12/2025 and the decree when the decree was passed.
Decree most probably within 15 days.
You are not aware of when the decree was passed.
Because I have not got the copy till date.
Is it not necessary to enclose the decree with the petition?
It is necessary. But
Then-
I may placed on, or it may be perused when LCR, TCR may be, will be called for. It may be perused. That's why I make a part of record the word decree in this petition.
You prefer this petition without knowing the date of the decree. You enclose the decree by filing an additional affidavit. Third, Mr. Epal, learned counsel for the petition. Mr. Pal submits that he may be granted some time to bring on record the decree passed by the learned first appellate court by filing an additional affidavit.
much
They are
time?
allowed. List the matter in the next week.
How much time? How much? 2 weeks time, maybe.
1 week, next week.
Because a copy is awaited, so sometime maybe 2 weeks.
Okay, after 2 weeks.
Problem.
Item 3.
In the morning hours, one advocate mentioned the matter Whether she has contracted you? No. So there was a pair of adjournment, but we could not grant it as no consent was obtained. So we'll call it after some time.
Item 4.
My lord, this is a revision petition. Actually, what happened, my lord, the petitioner bought a used car. And after some time of that purchase, his elder brother found dead in that car, for which allegation is that he was murdered, elder brother. So the vehicle also, my lord, was seized and under the police custody.
No, the question is this revision petition is preferred against the award, arbitral award.
Interim, my lord.
Is it
Actually, it is not yet final. Kindly come to page number 15.
whether this petition is maintainable?
My lord, if as per the Arbitration Act, my lord, there is the final award is not yet happened, my lord.
Mm.
So interim is under the section 17, my lord. So under that circumstance, civil revision can be, my lord, preferred, because otherwise there is no possibility for the petitioner to go to any other, my lord. Otherwise, in the matter, my lord, we are ready to pay the installments, and we have also informed twice, my lord.
No, we are not concerned with the merit of the petition.
My lord, my lord.
We are concerned with the maintainability of this petition.
Yes. Section 17, interim measures ordered by the arbitral tribunal. And we have also there are some certain discrepancy in the arbitral award as well as the seat also, my lord.
No. The question is whether this interim order is no, whether a revision petition lies against this interim order.
Well, under 227, actually, revision that is an inherent.
No. Problem is that this remedy is provided in the act itself. Can you show any decision of the any high court or any supreme court or the supreme court in
My lord,
respect
kindly
of
come to
maintainability of revision petition against interim
section 17, subsection 2.
17?
Yes, subsection 2.
Mm.
May I read, my lord?
Mm.
Subject to any orders passed in an appeal under section 37, any order issued by the arbitral tribunal under this section shall be deemed to be an order of the court for all purposes and shall be enforceable under the Code of Civil Procedure. So if it lies under the CPC, then revision can be done.
Enforceable. Order is enforceable.
My lord.
This is not about
In
the
the
revision
same
petition
manner,
or
but if it is enforceable under the CPC and CPC covers it, so my lord, I think the revisional power is also should be there.
your thinking or my thinking will not the matter, no? We'll take it up at 2 o'clock. In the meantime, you find it out any law is there,
My lord.
any case law is there.
In that case, my lord, may I pay for except today, my lord? Tomorrow or day after
Today you will not be able.
Yes, I have some, my lord, some personal difficulty.
On the prayer being made by Mr. D cannot learn a counsel for the petitioner. The matter stands adjourned to be listed on
Tuesday, my lord.
Tuesday, so it's not Tuesday,
Wednesday.
so as to enable Mr. Nath to satisfy this court regarding maintainability of this petition under Article 227 of the Constitution of India.
29 of like.
Timing item 3.
Please, your lordship. My lord, please adjourn the matter today as my senior is out of stations. I very need this chamber.
Your name, please?
And so do you.
And Sodori, Learned Counsel. Appearing on behalf of Mr.
M. Ahmed.
M. Ahmed, Learned Counsel for the petitioner. With consent from the other side, press for listing the matter after
1 week.
fair alone.
May it please your lordship, I'm challenging an order by which the maintenance amount was enhanced from 4,000 to 15,000. Your lordship may kindly peruse the title suit at page 14, your lordship. The husband, your lordship, the present petitioner has filed at page 14, your lordship may kindly peruse. Their marriage took place in the year 1987, and then he has filed a case in 2008 for resolution of his marriage. Had your lordship got that? Page 14, this is a petition under section 13(1)(1)(a), 1(b) of the Hindu Marriage Act 1955 for dissolution of marriage by decree of divorce. Now your lordship may kindly peruse the order at page 22. The order at page 22, your lordship. At page 22, your lordship, 18/6/2016. May I read, your lordship? Both sides are present. Seen the order passed by the learned secretary DLSA Tinsukia dated 18/6/2016, when it is intimated that the subject matter of the suit has been successfully resolved between the parties at Mediation Center Tinsukia. The aforesaid order is supported by memorandum of settlement under section 89 of the CPC read with section 24 of the Gauhati High Court Mediation Rule 2007. The said memorandum is marked as X, and the contents of it will form the part of the decree. After considering all aspects of the matter, the aforesaid reports are accepted after hearing both the sides on the matter. So the instance suit is disposed of on compromise without cause. As such, prepared a decree in accordance with terms and conditions as mentioned in the aforesaid memorandum of settlement. Now, your lordship, there was a settlement. I'm relying on page 26, your lordship. Page 26, clause F.
Page
26, your lordship. Clause F. This is the settlement which is annexed with the order and the decree, your lordship. Clause F, your lordship, that the petitioner herein agrees to pay the maintenance amount of rupees 4,000 only to the respondent in between first day of to the 10th day of every month by depositing in her bank account number so and so, State Bank of India, Margherita, from the month of July 2016. Now, your lordship may kindly peruse the decree, which starts from page 28. And I'm relying on paragraph 29 page, your lordship. Page 29, the instance suit is disposed of on compromise without cause. The memorandum of settlement marked as X shall form the part of the decree. At page 29, your lordship. So the maintenance amount order is not part of the decree, your lordship. Thereafter, this lady, your lordship, files a miscellaneous case at page 32. This is a petition, your lordship, at page 32, a petition under section 25 of the Hindu Adoption and Maintenance Act 1956. In my respectful submission, she cannot file a case, a petition under section 25 of the Hindu Adoption and Maintenance Act 1956, your lordship. And thereafter,
no, maybe misquoting or wrong quoting of any provision
yes, your
will
lordship.
not affect the merit of the claim.
True, your lordship. But your lordship, section 25, your lordship may kindly peruse for a moment.
No,
The
no,
Hindu marriage
the
act.
section 25 petition has been disposed of on compromise.
Yes, on compromise. No, not the section 25 petition, your lordship. The original petition for divorce was disposed of on compromise. Thereafter, for enhancements, he filed another case, and that petition was filed under section 25 of the Hindu Adoption and Maintenance Act, and not under Hindu Marriage Act 1955, your lordship. And that was disposed of, and the maintenance was enhanced. Now, in my respectful submission, this is not a decree, this is not a part of the decree, your lordship. So she cannot file a case for enhancement of the maintenance. She has a relief, your lordship. She can file it under 125 CRPC. Because if your lordship may kindly peruse page 20, the Hindu Marriage Act for a moment, your lordship. The Hindu Marriage Act 25. May I read your lordship? Section 25.
Yes.
Any court exercising jurisdiction under this act may, at any time of passing any decree or any time of subsequent thereto on application made to it for the purpose by either the wife or the husband, as the case may be, order that the respondent shall pay to the applicant for her or his maintenance and support such gross sum of such monthly or periodical sum for a term not exceeding the life of the applicant, as having regard to the respondent's source income and other property, if any, the income and other property of the applicant, the conduct of the parties and other circumstances of the case, it may seem to the court to be just, and any just payment may be secured, if necessary, by the charge on the immovable property of the respondent. Now, here, your lordship, I am harping on the point. Any court exercising jurisdiction under this act may, at the time of passing any decree or at the time of subsequent thereto. Now, your lordship, this decree, your lordship, this is not a decretal amount, your lordship. This amount of maintenance is not a decretal amount. And then section 25(2), your lordship,
No,
is the court-
maybe, or at any time subsequent thereto
Yes, your lordship.
on application made to it.
Yes, your lordship. That is what, your lordship. That is,
Hmm.
yes, your lordship, it is there, but that has to be a decretal amount in my full submission. That is not a decretal amount.
Let
It
notice
was just
go
a
address
compromise, your
it.
lordship.
Let notice go address
Yes,
it.
yes, your lordship.
Let the other side appear.
Yes, your lordship.
Heard Mr. Devi, Lord High Counsel for the petitioner. This petition under section 115 of the Code of Civil Procedure, read with section 151 of the Code of Civil Procedure. The petitioner has challenged the order dated 20th to 2026 passed by the learned additional district judge Tinsukia, applied to Tinsukia in Miss M case number 11 of 2022, arising out of titles of M number 56 of 2008. It is to be noted here that by impugn order dated 20th to 2026, the learned additional district judge FTC 2 Tinsukia, Assam, has enhanced the monthly maintenance payable by the petitioner to the respondent from rupees 4,000 to rupees 15,000 per month, with effect from the date of filing of the Miss M case number 11 of 2022, that is 6/8/2022. Peruse the petition and the documents placed on record, and also peruse the impugn order dated 20th to 2026. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Rest shall call for the record from the learned court below. Then, considering the submission of Mr. Devi, learned counsel for the petitioner, and also the facts and circumstances on the record, the petitioner is directed to make payment of 50% of the awarded amount to the respondent hearing till returnable date.
I'm very grateful, your lordship.
That is, the petitioners are the defendants in a suit filed for declaration, right title interest, declaration of right title interest and eviction, your lordship. The defendant's ground was that it is a separate plot of land as of the plaintiffs, and they are occupying a different plot of land. Under such circumstances, the report from circle officer was called for. So before going to the impugned order, at page 28 is the impugned order, page 27 order may be perused once, your lordship.
Page number?
Page number 27, annexure 5.
Hmm.
The report was submitted by the circle officer, which was in this order, which was agreed to by the plaintiff, and the defendant objected to it and prayed for calling the circle officer for examining him. It was allowed. And 5/2/2026 was fixed for examination of the circle officer on the survey report. The defendants were directed to take steps to summon the circle officer. Immediately on the next date, 5/2/26, Your Lordship, steps were not taken, Your Lordship, inadvertently, and for that matter, it was closed since it is an old pending case and it was proceeded for final argument, Your Lordship. This is the
What wrong with this order?
Lordship, there was a mistake on the part of the advocate that steps were not taken, but only one opportunity I am asking for, Your Lordship. The suit is next fixed on 28/4, Your Lordship, after
When?
4 days for final argument.
When?
Lordship, 28/4. Today is 24th. For final argument, Your Lordship. Unless the circle officer is examined, Your Lordship, the defendants will be prejudiced
No, that
because
opportunity was given to you. You have failed to avail the same.
one opportunity was given, Your Lordship. We have not taken steps, Your Lordship.
How many opportunities are
Lordship, on-
opportunities you are entitled to?
Lordship, one is sufficient, Your
When
Lordship.
the suit was filed?
In the year 2016. On 19/12/25, Your Lordship, the order was passed for
Mr.
taking steps.
Mukherjee, learned counsel for the petitioner. This petition under Article 226 of the Constitution, 227 of the Constitution of India, the petitioner has challenged the order dated 5/2/2026 passed by the learned civil judge, Senior Division Boyno, in TS number 30 of 2016. It is to be noted here that by the impugn order dated so and so, the learned trial court has dismissed the petition number 414 of 2026. Where is the petition?
Lordship, that is not on record, Your Lordship. The adjournment petition is not on record.
212, line 2. Dismiss the petition filed by the learned counsel for the petitioner or adjournment of the case. Mr. Mukherjee, learned counsel for the petitioner submits that the petitioners are the defendant in title suit number 30 of 2016, which is pending before the Court of Learned Civil Judge, Senior Division, Boyno. Mr. Mukherjee further submits that a survey report in the said title suit, a survey report was called for from the circle officer. And accordingly, the circle officer submitted the report on 22nd of August 2025. The petitioners herein then prayed for allowing them to examine the circle officer. And by order dated 19/12/2025, the pair was allowed. But due to the mistake on the part of the engaged counsel of the petitioners, step could not be taken upon the circle officer, for which the petitioners have been denied the opportunity to cross-examine the circle officer. And by impugn order dated 5/2/2026, the evidence was closed and the case is posted on 11/3/20 was posted on 11/3/2026 for argument, and now the date is refixed on 28/4/2026. Mr. Mukherjee further submits that only one opportunity may be granted to the petitioner to cross-examine the circle officer, else serious prejudice will be caused to them. Having heard the submission of learned counsel for the petitioner, this court has carefully gone through the petition and the documents placed on record and also perused the order dated 5/2/2026. It appears that only one opportunity was given to the petitioners hearing to examine the circle officer, but due to mistake on the part of the counsel, engaged counsel of the petitioners, step could not be taken for which the learned trial court, by impugn order dated 5/2/2026, have closed the evidence and posted the case for agreement. It is well settled that for the fault of advocate, the petitioners should not suffer. And taking note of the aforementioned facts and circumstances and also the submission of Mukherjee, this petition stands allowed that this motion is itself subject, however, to payment of the cost of ₹5,000, which shall be deposited before the learned trial court on or before the next date of hearing. In terms of this civil revision petition stands disposal.
Obliged.
Yes, next item.
Wait, please, Your Lordship. Your Lordship, I am the defendant 8 in the title suit, and the respondent number 1 is plaintiff. They filed a title suit for cancellation of agreement of sale between the petitioner's hearing and respondent number 2 to 8. Now, during the course of the proceeding, the respondent herein has filed one petition under section 15(2) of the Commercial Act for transferring the entire suit to the Court of Commercial Court at Dibrugarh. So the court, after going through that petition, has transferred the entire matter to the Commercial Court, saying that the entire relief that falls under 2(1)(c) of the Commercial Court Act. Now that as per the decision passed by the apex court, that is totally contrary to it. Inasmuch as your lordship may first come to the finding at page 114. I'll read from second paragraph. The next objection raised by the contending defendants are that the present suit does not constitute a commercial dispute within the meaning of section 2(1)(c) of the Commercial Courts Act 2015 and therefore not liable to be transferred. The suit has been instituted by the plaintiff firm seeking declaration, injunction, and cancellation of an agreement for sale dated 16/12/2005 and alternatively for a money decree amounting to 1,70,90,262. The transaction in question arises out of a business commercial dealing entered into by the plaintiff firm in the course of trade and commercial activities. Now, 2(1)(c) of the Act defines a commercial dispute to include dispute arising out of ordinary transaction of merchant, bankers, traders, business entities, as well as agreement relating to immovable property.
Mr. Dotto, you tell
Yes.
me, is it not a commercial dispute?
No, because the apex court has said that to qualify as a commercial activity, the claim which has been sought for or the relief sought for, that property has to be specifically used and actively used for commerce and trade at the time of making the agreement under 2(1)(c). So if your lordship comes to the plaint now, at page 37.
No, you
Yeah.
come to the definition clause 2(c).
The definition, yes,
2(1)(c).
2(1)(c). 2(1)(c) states that 2(1)(c) specifically they are relying on 2(1)(c) 7. Agreements relating to immovable property used, this part is important, used exclusively in trade or commerce. Now the agreement in the present case that was not being used exclusively in trade and commerce because at the time of making this agreement, this T state, the subject matter of the agreement, Duliavam T state, that was a Sikh company, and they have admitted the same itself in the plaint, which I'll take your lordship to. Lordship will come to page 46, the plaint, the operative part of the plaint.
Page number?
Page number 49. 46, your lordship. 46, para 5. The para starts with Duliavam, that Duliavam T state, as has been stated earlier, has been running under loss for last 4 to 5 years and had incurred heavy liabilities in the market, including in favor of the plaintiff. So as the entire T state was under heavy loss, agreement was entered between us and the owners of this Duliavam T state to acquire the entire T state. Now, when the entire T state is running at a loss, how can it be exclusively used for trade and commerce? So that is the precise point, Lordship. And secondly, they have another prayer which they have sought for. The prayer portion, your Lordship will find at page 54. Page 54, point number 5. Alternatively, a money decree for rupees 1 crore 70 lakhs and odd. So these 1 crore 70 lakh, whether it arises out of this transaction, commerce and trade activities, and whether any quantification has been made, nothing has been stated in the entire plaint. If your lordship goes through the entire plaint,
No, that will be decided during the course of trial.
yes, but precisely
The issue before this court is whether
the
the
agreement.
matter does not fall in the category of 2C, 213
yes.
of the Commercial Court Act or not.
So
Let notice go at this. Heard Mr. Dr. Learned Counsel. This petition under Article 227 of the Constitution of India. The petitioner has challenged the impugned order dated 22nd of December 2025, passed by the Learned Civil Judge, Senior Division, Dibrugarh, in titles of number 03 of 2026, filed by the respondent number 1. Respondent number 1. It is to be noted here that by the impugned order dated so and so, the learned trial court has transferred the case transferred the titles of number 03 of 2006 to the Commercial Court at Dibrugarh under Section 15(2) of the Commercial Court Act 2015. Mr. Dr. Learned Counsel for the petitioner submits that the dispute between the parties does not fall in the definition of commercial dispute as described in Section 2C, 21C of the Commercial Court Act 2015. And as such, the impugned order dated so and so, transferring the case to the Commercial Court at Dibrugarh is illegal and arbitrary. The submission of Mr. Dotton is further consideration at this is notice be issued to the respondents returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Call for the scan copy of the record from the learned trial court. List the matter after 4 weeks.
Your lordship, till then it may be state the title suit.
Interim pair of the petitioner will be considered on next returnable date.
Obliged.
May it please your lordship. The petitioner is the defendant in a money suit, lordship. The plaintiff prayed for re-examination of PW1 and PW2 that was allowed, and thereafter they filed an amendment application, lordship. That is Annexure 5, page 33. The respondent filed this petition. The above named plaintiff submits for amendment of evidence as follows. That today the suit is fixed for re-examination of PW1, PW2 and official of CGM Dhubri. That the plaintiff has PW1 submitted his re-examination in chief in this court and exhibited documents 13, 14, so and so up to 19, lordship. That the PW1 in evidence in chief, though required to mark the documents as exhibit 23, 24, 25, 26 and 29, but due to type mistake, the marking of exhibits were made wrongly as 13 to 19, lordship. So they prayed to change the number of the exhibits, and accordingly the learned trial court, though we filed an objection that evidence in chief cannot be amended, lordship. But court has not taken into consideration that objection. Thereafter, the amendment was allowed, lordship. Basing on a judgment of Supreme Court, that is Civil Appeal number 5909 of 2022, page 41, lordship. 15/10/2025 order. Plaintiff based their argument on the basis of this judgment, and this judgment is, lordship, that is Life Insurance Corporation of India, that is on amendment of plaint and written statement. Order 6 rule 18. So when the plaintiff filed their petition for amendment of the evidence and relied also on the decision of Supreme Court for amendment of amendment, thereafter they did not amend their evidence in chief of PW1. So we filed an objection petition, that is Annexure 9, page 44. That though amendment was allowed, but he has not, lordship, amended his evidence in chief within mandatory period of 14 days. So this amendment may be, lordship, rejected. But court has not, they filed objection against my petition, but court has not taken into consideration. By impugn order, my petition was rejected. The impugn order is dated 7/3/26, page 49, Annexure 11.
So how this impugn order is illegal or arbitrary?
Lordship, that if amendment is allowed by the court, it is the mandatory requirement of Order 6, Rule 18 to amend that part within a mandatory period of 14 days. If no time limit was granted by the court. May I read Order 6, Rule 18? Failure to amend after order. If a party who has obtained an order for leave to amend does not amend accordingly within the time limited for that purpose by the order, or if no time is thereby limited, then within 14 days from the date of the order, he shall not be permitted, lordship, to amend after the expiration of such limited time as aforesaid, or of such 14 days as the case may be, unless the time is extended by the court. So their objection clearly reflects that they presume that court extended the time, lordship. Their objection petition, lordship, kindly see this page number. Page
No,
47, Lecture 10.
when Order 6 Rule 18 CPC will be applicable?
When amendment was granted by the court, lordship.
Amendment of?
amendment of plain written statement, and they say.
Here, is it the case of the
No, Lordship. They,
petitioners that it was the
No,
pleadings?
so, Lordship, so I have prayed that
No,
there
then
is,
how this provision will be applicable?
because they filed the petition for amendment, Lordship.
No, amendment for evidence, not
Yes,
for
Lordship.
pleadings.
No, Lordship. So amendment is, Lordship, as per Order 6, Rule 17 only. So if amendment was allowed by the court, then mandatory provision of Order 6, Rule 18 will come.
No, that will be applicable only in case of pleadings. Here
Pleadings,
it is
Lordship.
not the pleadings, it is the evidence.
But Lordship, there is a judgment of Supreme Court which says Order 6, Rule 18 is mandatory, Lordship.
Mandatory, that's all right, in respect of the pleadings.
Pleadings also, Lordship, in evidence.
Whether pleadings and evidence are same thing.
Yes, Lordship. So we have
No,
objected.
you answer my question.
Lordship.
Whether pleadings and evidence are same thing.
No, Lordship.
Then
we objected in the first petition that evidences cannot be amended. There is no provision for amendment, but the plaintiff relied on the judgment of amendment, Lordship. Thereafter, court granted amendment of the prayer of the petitioner, Lordship. So it presumed that amendment of the evidence was granted, Lordship. So if amendment was granted, that mandatory provision of amendment Order 6, Rule 18 will be applicable.
No.
Lordship, kindly see this judgment, Union of India versus Pramod Gupta, paragraph 138 and 140, Lordship. This is the judgment, Lordship. And that is the Life Insurance Corporation, Lordship, that was relied by the plaintiff while allowing their first petition, Lordship. Paragraph 138 and 140, Lordship.
No, this is in respect of pleadings.
Yes, Lordship.
You have admitted that pleadings and the evidence are not the same thing.
Yes, Lordship.
Then how can we apply this provision?
Then, Lordship, their first order is not as per law, Lordship.
That is not challenged in this
Lordship,
petition.
I have challenged both the orders, Lordship. 7/3/26 as well as, Lordship, order dated 15/10/2025, page 2, Lordship.
Okay, we'll say, let notice go.
Lordship.
Is also there when I counsel for the petitioner in this petition under Article 227 of the Constitution of India, read with Section 151 of the Code of Civil Procedure. The petitioner has challenged the order dated 7/3/2026, passed by the learned civil judge, Senior Division Rowry, in Manuscript number 6 of 2016. It is to be noted here that by the impugned order dated 7/3/2026, the learned court below has rejected the petition bearing number 1798 of 2026 filed by the petitioner under Order 6, Rule 18, CPC, seeking rejection of the proposed amendment stroke correction of the plaintiff's evidence for failure to carry out such amendment within the prescribed time. Peruse the petition and the documents placed on record, and also peruse the impugned order dated 7/3/2026. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. List the matter after 4 weeks.
Lordship, next date is 27/4 for
Maybe.
page 52, Lordship.
Maybe.
Lordship, in the meantime, re-examination will be proceeded.
No.
Till, Lordship,
No,
fix
no.
after 4 weeks, any
No.
date until
No.
then date, Lordship.
So Ms. Soduri has submitted that there is a requirement of staying the impugned order dated so and so. Yet, to appointed query of this court, Ms. Soduri submits that amendment of pleadings and amendment of evidence are not the same thing. And though she submits that the provision of Order 6, Rule 18 will be applicable in the present case, the said submission left this court unimpressed, and therefore this court is not inclined to grant any interim relief at this stage. List the matter after 4 weeks.
That my interim prayer may be considered on returnable
Sorry.
date, Lordship? On returnable date, Lordship.
No.
Obliged.
Item 4, orders, item number 21, shorter matter.
What is it? After some.
Item 22,
Lord, we took alternate mode of service, my lord, paper publication upon respondent number 2, and we filed an affidavit, my lord. Last time it was not in record, my lord.
Hmm. Heard Mr. Chakraborty, learned counsel for the applicant. This I is for?
For alternate mode of service, my lord, for paper
No,
publication.
no, no, no. This I is for?
I am, my lord, 2816.
Yes. No, no. IA 2616.
For substitution of legal heirs, my lord, of this is respondent number 1. That is done already. That is already done.
Substitution done.
Yes, sir. One measure. He is appearing, my lord.
I am appearing for one. Okay.
Only for 2, my lord.
Paper publication was for two.
And there is another I am, my lord, 2618.
No, this I is a dispose of 2616.
Yes, my lord, it was disposed of. It was disposed of, my lord, because he has already appeared.
And also heard Mr. A Sigdar, learned counsel for the opposite party number 1. Mr. Chakraborty submits that after effecting service upon respondent number 2 by substituted mode. Question bracket paper has submitted in affidavit to that effect before this court. And since service upon the respondent number 2 deemed to have been completed, and since no one remained, since no one entered appearance on behalf of respondent number 2, the matter may be listed. The other two I's are for?
My lord, one was for substitution of legal heirs and another for, my lord, setting aside abatement, my lord. Two 2618 for setting aside abatement, my lord.
Two, 6, 1.
8.
The application filed under order 22 rule 9 for setting aside the abatement may be allowed. Any objection, Mr. Sigdar? Mr. Sigdar, learned counsel for the respondent number 1 submits that he has no objection. Accordingly, taking note of the submission of learned counsel for both the parties and also considering the facts and circumstances on the record, this petition stands allowed. Abatement. of RSA number 85 of 2010 on account of death of Mohammad Abdul Riaz. The appellant then set aside and set aside. In terms of this IA number 2618 2019 stands allowed. And the other IA 2612
This is for condonation of delay, my lord. In
limitation.
yes,
It was not allowed.
no, to set aside abatement. Well, actually, this is not required because earlier, my lord, we used to file separate petition for condonation of delay. So now Supreme Court says, my lord, in the event of setting aside abatement, it goes, my lord. So we
Okay.
have filed this,
You are not pressing this now then.
but it can be disposed of, my lord, in view of the this petition 2618 being allowed, my lord.
No.
This is for,
You say this petition ought to have been, this application ought to have been disposed of first.
Yes, my lord, yes. In view of 2618 being disposed of, my lord, this can be also disposed of, my lord.
Third, Mr. Chakraborty, learned counsel for the applicant. His application under Section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 617 days in preparing the application for setting aside abatement and substitution application for legal heirs of. This is respondent number 1. So what is the ground of delay?
Or actually, my lord, I have stated in paragraph 44, my lord, of my petition. Four also in 7, my lord, stated my reasons.
There was change of counsel.
Yes, my lord, yes.
Mr. Chakraborty, learned counsel for the petitioner submits that due to change of counsel, the application could not be filed in time. And the same has been explained in paragraph number 4 and 7 of the application. And that the delay is not intentional, rather it is circumstantial, and therefore it is contented to condemn the same. Mr. Sikter submits that he has no objection in the event of condoning the delay. Accordingly, taking note of the submission of learned counsel for both the parties and also considering the explanations so forthcoming for the delay, this court is of the view that the same has sufficiently been explained, and accordingly, the delay of 617 days in preparing the application for setting aside abatement and substitution application stands condemned. And in terms of this, IA stands closed. Now you have to file a amended cost letter.
Yes. Yes, that I can, yes, that I have to.
In view of the order passed in IA number 2612 and 2618. Mr. Chakraborty, learned counsel for the counsel for the appellant shall file amended cost title in RSN number 85 of 2010. 2010 within a period of 1 week from today. Recessal is the matter after 2 weeks or 1 week?
1 week.
1 week. Restoration petition was earlier disposed of.
Yes, my lord.
17, I number 1703 of 2018.
Yes, please. Dispose of.
Pending.
I'm sorry, 03.
Whether it was a disposed of.
My lord, my lord, so far as this order is concerned, 29/4/2019, it says registry to issue notice to the appellants to the effect that the learned counsel representing them had withdrawn the wakalatnama. Subsequent to that, I have filed my wakalatnama, my lord. 708.
Heart Mr. Chakraborty, learned counsel for the petitioner, and Mr. Sigdar for the respondent number 1, opposite party number 1. In view of the order being passed in I number 2616, I number 2611, and I number 2618 of 2019. The REC number 85 of 2010 stands restored to the file. In terms of this, I number 1703 of 2018 stands disposal.
All right.
Standing item 21.
Contempt case, both the council be subsequent and in they were not able to attend before this honorable court. Kindly adjourn this matter for 1 week, okay?
Or
Kindly adjourn this matter for 1 week because B Kaushik and PN Sharma both are not well to attend before this honorable court, okay?
okay. Heart Mr. R. Islam, learned counsel for the petitioner, and Ms. Deka,
Okay.
learned counsel for the learned counsel appearing on behalf of Mr. PN Sharma.
PN Sharma.
PN Sharma. Ms. Deka submits that the required information, the required instruction could not be obtained as Mr. Sharma is suffering from illness and could not appear before the court today. And she prays for listening the matter after a week. Bear allowed, recess list the matter on fixed date.
Twice.
Number 24.
service upon respondent number 1 has completed, but respondent number 2 refused, stating that his name and his father's name does not match with the actual names. I pray for striking out the name of respondent number 2. He is not a necessary party.
Heard Mr. Mukherjee, learned counsel for the petitioner, Mr. Nandi for the respondent number 1. Mr. Mukherjee submits that the respondent number 2 refused to accept the notice on the ground that, what is the ground?
Not a necessary party. He refused, stating that his name does not match. His surname does not match.
On the ground that his surname does not match with his actual name. Mr. Mukherjee further submits that the name of respondent number 2 may be struck off from the array of this petition. Prayer allowed at the cost and risks of the petitioner, the name of respondent number 2 be struck off from the array of this petition.
I am for the respondent number 1.
In view of above, let's establish the matter for admission
Admission.
hearing. After 1 week,
Yes. Much of-
25.
Morning, Your Honor. If Your Honor, this is a transfer petition filed by the petitioner who happens to be the respondent in the matrimonial proceeding in FC court, in the FC case number 1236 of 25, which is filed in the family court of Kamrup. Your Honor, this petitioner, hearing the petitioner, she is a government employee at the Goalpara B.Ed College, and she also happens to have the full exclusive custody of a child who happened just turned 2 years last November 2025. And unfortunately, this child also happens to be a premature baby who was born
28/4/2026 indicates that service upon respondent, sole respondent stands completed. In view of above, let's establish the matter for admission after a week.
May I also request Your Honor, the next listing date in the family court is on 28. So until the disposal of
No, we'll
disposal of-
finally hear and dispose of the matter after a week. Fixed date after.
may the
1 week.
proceeding in the family court may be stayed.
Finally,
obliged, Your
we'll
Honor.
dispose of the matter, granting.
13th May. Obliged, Your Honor.
Item numbers 26 and 27.
Maybe 12 is more than a logic.
They have not filed their affidavit yet, my lord.
Hmm?
They are supposed to file their affidavit, my lord.
No, in a review petition, whether affidavit is required.
Yes, my some new facts have been brought to my lord, with they have to respond to that, my lord. They have not responded.
Heard, Mr. Purkesto, learned counsel for the petitioner. And Ms. Terampi for the respondent. Ms. Terampi, thanks for granting her some more time to file the affidavit in opposition. Fair allowed, let's establish the matter. After 1 week,
We got it. 1 week it will be too early.
fix a date.
Let go.
18. May.
Right.
Item 28.
Back to Lordship, my lord. My lord, the main grounds that there is only a delay of 7 days, my lord. We have stated this in para 2, page 30, my lord, where we have filed additional affidavit.
This I is for
Condonation of delay, my lord. Condonation of delay, my lord.
any objection?
Can you fill the alia logic?
Yes.
Page 5, logic para 9. Here we have stated that the applicant herein begs to state that the delay of 7 days in filing the petition under section 104 of this Code of Civil Procedure, like over there is also opening the order dated 17/6/25, passed in April 7/24, passed by the London Court of Civil Judge Golaphat only because the certified copy of the order dated 17/6/25 was received on 30/6/25 launching. And thereafter they have filed an additional.
So only 7 days delay.
Then lordship, my objection will be recorded lordship, only that. Delay has not been explained lordship.
That is our bona fide mistake, my lord. We honestly confess, my lord, that is our bona fide mistake, my lord.
Heard Mr. S.S. Rahman, learned counsel for the petitioner, and Ms. Das, learned counsel for the applicant, and Ms. Das for the respondent, opposite party. This application under section 5 of the Limitation Act is preferred by the applicant for continuation of delay of 7 days in preferring civil revision petition. Under section 104 of the Code of Civil Procedure, read with order 43, rule 1R of the Code of Civil Procedure. The learned counsel for the applicant submits that on account of his fault, which is a bona fide one, the petition could not be filed in time. And the same has been explained in the additional affidavit in paragraph number 3. And under such circumstances, he has contended to allow this application. Ms. Das, learned counsel for the opposite party, however, opposed the petition on the ground that the delay has not been properly explained. Having heard the submission of learned counsel for both the parties, this court has carefully gone through the petition and the documents placed on record, and also the additional affidavit dated 21st of April 2026 filed by the applicant. It appears that on account of the mistake on the part of the engaged counsel, the application could not be filed in time. And the same appears to be a bona fide one. And in that view of the matter, the delay of 7 days in filing the present application, no, in filing the connected civil revision petition, appears to be sufficiently explained. And as such, this interlocutory application is then allowed. Delay of 7 days in filing the connected civil revision petition stands condoned. In view of the order passed in the IA, now the registry will proceed to register the civil revision petition and list the same before the court as soon as practicable.
Highly obliged, my lord. Obliged, my lord.
May we please, my lordship. In this matter, the notice issued to the sole respondent yet to complete. As per office note dated 24/2020.
Heard Mr. Thakuria, learned counsel for the applicant. No, learned counsel for the petitioner. Office note dated 28/4/2026 indicates that neither service report nor it occurred in respect of service of notice. No, neither AD card nor unserved notice issued to the respondent returned till date. List the matter after 2 weeks, awaiting service report upon
That may
respondent.
be fixed, my lordship. That may be fixed, my lordship. Masuk, my lord.
My lord, brief fact of this case is that, Your Honor. Pardon? My lord, brief fact of this case is that, my lord. No, service is yet to be completed. You have not taken any step. My lord, I have taken steps, my lord. When? I have taken step 22 January 2026, my lord. No, thereafter, one office notice, they are dated 16/3/2026. My lord, heard, Mr. Your name, please? Procedural, my lord. Learned counsel for the petitioner. My lord, this is the office note dated 16/3/2026 indicates that neither ID card nor answer notice returned to the section till date in respect of service of notice. No, in respect of issuance of notice to the respondent. Said office note also indicates that step for issuance of notice upon the respondent by way of usual court process have not been received by the section till date. This is the trade consignment report, my lord. As per trade consignment report, my lord, on 28/2026, my lord, the notice has been served, my lord, to the respondent. My lord. However, a learned counsel for the petitioner has produced one report of postal department in respect of delivery of the notice upon the sole respondent. From where do you got it? My lord, I have received from discuss section the article number, my lord. Thereafter, my lord, we have searched. Where is the document to show that this is your document number? My lord, consignment number is ES 060284123E. No. What is the document to show that this is your consignment number? My lord, this is the consignment number, my lord. I have taken steps, my lord, as per this. No, is there any document with you to show that this is your consignment number? My lord, and this section, then the. Okay, you obtain the certificate copy from the dispatch department. Dispatch section, we will see it. However, there is no indication in the said report that the consignment number ES 060284123IN belongs to the present petitioner. The learned counsel for the petitioner is accordingly directed to furnish any supporting document in respect of the same. List the matter on. Okay, next. 4th of May.
Petition for transfer of a divorce proceeding from Lakhimpur to Gauhati.
My lordship, before my senior starts, my lordship, on last occasion, we have sought time with regard to filing a Hukalan. My lordship, the respondent, he could not travel from, as he didn't got leave, he could not travel back from Hyderabad to file Hukalan, but he has stated to WhatsApp that he has no objection with regard to the transfer of the proceeding.
Okay.
My lordship, one submission, my lordship, since the family court matter hearing requires the appearance and the participation of the petitioner and the respondent, because step clients, So my lordship, he has requested that if GC proceeding or any such mode, because he is not getting, he stays at
No,
Hyderabad.
no, this court cannot direct it. You file an application before the concerned court.
Yes, my lordship.
The court will consider the same.
Believe that recordment that I may file an application, if that be recorded, my lordship. In the order.
Well, no objection.
Heard, Mr. Somo, learned counsel for the petitioner, and Miss Borua, learned counsel, who entered appearance on instruction, however, without filing any kalatnama. Mr. Somo, learned counsel for the petitioner, submits that this application under section 24 of the Code of Civil Procedure, read with section 31, within bracket, Roman 1, Roman 2, Roman 3, Roman 3A of the Special Marriage Act 1954, is preferred by the petitioner seeking transfer of title suit, within bracket D number 42 of 2024, which is pending before the Court of Learned District Judge Lakhimpur to the Court of Learned Principal Judge Family Court at Kamrup. Ms. Somoa, learned counsel for the petitioner, further submits that the petitioner is the wife of the respondent who resides at Gauhati.
Yes, go ahead.
Gauhati. Gauhati. And that her marriage with the respondent was solemnized in the year
Is it 2010?
on 22nd of June 2010 at Gauhati. And thereafter they lived together as husband and wife at
In New Delhi. Milord.
New Delhi.
Huh.
At New Delhi. And subsequently, marital discord surfaced between them, and the petitioner herein is residing at Gauhati since
Since 2018, 28 August 2000, oh sorry, since 2000, in April 2017, from April 2017.
from April 2017, and the respondent herein is residing at Lakhimpur,
No, my lordship,
No,
he's
he's
working in Hyderabad.
Hyderabad.
working at Hyderabad. However, the respondent herein has instituted one title suit, within bracket D number 42 of 2024 for dissolution of their marriage before the Court of Learned District Judge Lakhimpur,
As he's a permanent resident of Lakhimpur, my lordship.
as he is a permanent resident of the said district. Mr. Somuva further submits that
Special minister.
Lakhimpur.
since the petitioner is residing at Gauhati, it is not possible on her part to contest the aforementioned proceeding before the Court of Learned District Judge at Lakhimpur, as the distance between Lakhimpur and Gauhati is
Around 20.
around 320 kilometers. 320 kilometers, and under the above mentioned circumstances, the petitioner has approached this court by filing the present petition for transferring the title suit D number 42 of 2024 to the Court of Learned Principal Judge Family Court at Gauhati, Family Court Kamrup at Gauhati. Ms. Borwa submits that the respondent herein has no objection in the event of transferring the aforementioned suit from Lakhimpur to Gauhati. However, she submits that the petitioner may be, the respondent may be allowed to appear in the said proceeding through VC. Madam, having heard the submission of learned counsel for both the parties, this court has carefully gone through the petition and the documents placed on record, and also placed on record. And it appears that the petitioner is presently residing at Gauhati, whereas the title suit, D number 42 of 2024, is instituted before the Court of Learned District Judge at Lakhimpur. The distance between Lakhimpur and Gauhati
It's
is
360 kilometer.
360 kilometer, and as such, it would not be possible on the part of the petitioner to undertake such a tedious journey and to contest the proceeding before the Court of Learned District Judge at Lakhimpur. Moreover, the respondent herein has no objection also in the event of transferring the aforementioned proceeding from the Court of Learned District Judge to the Court of Learned Principal Judge Family Court at Kamrup at Gauhati. Accordingly, taking note of the submission of learned counsel for both the parties and also the facts and circumstances on the record as stated herein above, this petition stands allowed. Title suit within bracket D number 42 of 2024 stands transferred from the Court of Learned District Judge Lakhimpur to the Court of Learned Principal Judge Family Court number 1 Kamrup at Gauhati. Kamrup at Gauhati. The petitioner herein shall obtain a certified copy of this order and place the same before the Court of Learned Principal Judge, Learned District Judge at Lakhimpur. And on receipt of the same, the Learned District Judge Lakhimpur shall forthwith transmit the record to the Court of Learned Principal Judge Family Court at Gauhati. In terms of above this, transfer petition stands disposed of.
With regard to filing of the
Okay. With regard to the regard to the submission of Ms. Borua, Learned Counsel for the respondent, it is provided that the respondent herein shall file an application before the Principal Judge Family Court at Gauhati, and on such petition being filed, the Learned Principal Judge Family Court at Gauhati shall consider the same in accordance with law.
Well, one small accommodation, Miller. Next date is on 28 April, Miller. Today is 24th. 25th.
Whether any stay order is operating?
No.
No.
That is why, Miller. On 28, we were supposed to file our WS. And we have not prepared it because this petition is pending.
No, that's all right. You produce a order, copy of this order before the district judge.
That is what, Milord. On 28, Milord, I am not sure whether it will be possible to reach there because 25 and 26 is holiday.
No. This will be made available in the website today.
My lord.
You
Then
obtain a copy.
My lordship, I made a submission that it was filed for district judge as permanent resident of Lakhimpur. One more thing is that it was a special, the court marriage was done at Lakhimpur, my lordship, actually. And because the other special.
No jurisdiction.
My lordship has asked, so I.
Obliged.
May it please your lordship, as per office note dated 22/4/26, service has been awaited.
Heard, Miss?
S. Sharma,
Learned Counsel for the petitioner. Office note dated
22/4/26.
22nd of April 2026 indicates that neither AD card nor unserved notice issued to the respondent returned till date. When you have taken step?
Lordship, we have taken steps on 17/3/26.
List the matter after 2 weeks, awaiting service report upon the respondent.
Obliged.
But the service is not complete, but the challenge in this case is whether the rejection of an impleadment application. Now,
My lord, the loan was taken by the father of the defendants and plaintiff. It was mortgaged with the bank. We filed a case before the Debts Recovery Tribunal. It has been decided against them. So, my lord, all these things were written in the impleadment application, but only thing that no document was furnished. On that ground, it was not allowed, my lord. So, my lord, as my lord, service is not complete, my lord, and the next date is on 16th, my lord. So if your lordship directs that we await for service report, my lord, then humbly pray that the proceedings before the trial court be stayed. Alternatively, my lord, if your liberty is given that we will appear on the date and we will file an application, and the court will consider it, the case on its merit, my lord. Then, my lord, the case will also proceed, my lord. Otherwise, my lord, the judgments of the tribunal is there. I have annexed, my lord. These all the 4 lands, my lord. It has been mortgaged with the bank. Now, when they found that they have not been able to succeed in all the proceedings, then they filed the suit, my lord. And suit for partition, it is not only a suit for partition, because if your lordship, my lord, kindly comes to the plaint, which starts from page 28. And the prayer, my lord, plain starts at 28, my lord, and prayer portion, page 36, lordship will kindly see. That is not only a partition suit simpliciter, my lord. 36, page 36, my lord, lordship got it, my lord. Serial number A, decree for declaration that the undivided right title, interest and possession of the plaintiff over the suit land ABCD of the plaintiff, and that the any act, and this is important, my lord, any act of the defendant number 1 by creating sale, mortgage, lien, etc. behind the back of the plaintiffs. So, my lord, the father had stood as a guarantor. The son had taken a loan from the bank. They could not pay it. The case was filed before the Debts Recovery Tribunal. My lord, judgment, your lordship will find at page 46. 2 cases were filed before the Debts Recovery Tribunal, my lord. Page 46, lordship will see, my lord. Lordship got it, my lord. OA 520 to 2016. This is in respect of, my lord, 3 lands, schedule A, B, and D, and another, my lord, judgment at page 63. At page 63, that is in respect of schedule A, B, C. So page 63, my lord. So in all the cases, my lord, this land, the mortgage which was created, that has been held to be kept alive, my lord. The bank can proceed for recovering its dues, my lord. So, my lord,
No, Mr. Das, you say unless the service is completed, we cannot pass any effective order.
that is, my lord, on last date, my lord, lordship, on last order, lordship had said, but because if we have to, my lord, so we wait for the service report. Lordship's last order that interim will be considered today, my lord. That day I didn't rest much for the interim because other side was not there. Now, since today service is not complete, so let, my lord, till the next, lordship will fix it till the next day. The further proceeding be state, let them come and appear. Because it is fixed for evidence, my lord. My lord, if the evidence continues, then again filing.
No, you file an application there that one civil revision petition is pending before this
My
court.
lord, the problem is that nowadays, my lord, until and unless there is a specific direction, the trial court says that, see, there is no direction staying the proceedings, so we should proceed. So that is the difficulty. When moreover, my lord, as the petitioner is not a party, so if an application is filed, the court will not entertain, my lord. So may I pray that lordship will fix a, my lord,
the reality.
my lordship will fix a, my lord, 2 weeks or date for service of
No, we can allow Dusty service.
they will not be possible because they will avoid, my lord, because so much of litigations. And it is in Sonapur, my lord, difficult to trace also, my lord.
Why?
So,
Sonapur is a
lordship will
small
fix it, my lord, in after 3 weeks, lordship will fix a date, my lord. Till then, my lord, let the proceedings be stayed. Let them come and appear. Or, my lord, alternatively, lordship will dispose of that with a liberty to that we'll go and file an application, proper application with documents before the trial court. Then, my lord, the suit will also proceed. There is, the court will consider it on its own merit, my lord. So only reason is that court said that that no document was filed, my lord. So the, in the impugned order, lordship will see the operative portion.
That
at
page
pa-
number?
Page 122, my lord. Page 122, I am reading the operative portion, my lord. Lordship got it, my lord. The OPs, the OPs plaintiff filed title suit number so and so praying for declaration of right title interest over the schedule A, B, C, D land and to declare the act of the defendant number 1 by creating sale, mortgage, lien, etc. is not binding upon the plaintiffs. In deciding such prayer, the absence of the present petitioner is not found necessary, and in absence of the petitioner also, an effective order can be passed on the prayer of the OP's plaintiffs. On the above facts and circumstances, and in absence of any document in favor of the petitioner, the prayer of the petitioner to implead it as necessary party to the suit as per so and so is rejected. Now, in a case of our
So, is it your case that without any document? you have
document,
filed the
that is
application?
what. So if your lordship, my lord, instead of keeping this matter pending, my lord, the liberty is given to us that we'll file an application, proper application before the trial court, and the trial court will consider it on its merit. So in that event, my lord, the other side also get an
Okay,
opportunity.
okay. Heard, Mr. A. Das, learned counsel for the petitioner. Office note dated 21/4/2026 indicates that neither AD card nor answer notice in respect of the respondent number 1 to 10 received back by the section till date. Mr. Das submits that the next date is fixed before the learned
On
trial court on
16/5, my lord. Lordship will find that page
on
it's
on
16/5.
16/5
16/5.
16/5/2026 2026, and he also pointed out that by impugn order dated 22nd of August 2025, the learned trial court has dismissed the application filed by the petitioner under Order 1 Rule 10 CPC, read with Section 151 of the CPC, on the ground that on one of the ground that the petition was not supported by any document. In that view of the matter, Mr. Das submits that instead of keeping this matter pending here, it may be disposed of granting liberty to the petitioner to approach the trial court again by filing an appropriate petition with the relevant documents. Para, the submission of Mr. Das, learned counsel to the petitioner, received due consideration of this court. And also, this court has carefully gone through the record, especially the order dated, impugn order dated 22nd 8/2025. Accordingly, taking note of the submission of Mr. Das, learned counsel for the petitioner, and also considering the facts and circumstances on the record, this court is inclined to dispose of this petition, granting liberty to the petitioner to approach the learned trial court again by filing appropriate petition under Order 1 Rule 10 CPC along with supporting documents, and on such petition being filed, the learned trial court shall consider the same in accordance with law. And to the extent indicated above, the impugn order dated 22nd of August 2025 stands interfered with.
I'm deeply obliged.
May I please your lordship? Lordship, item number 34 and 35 are analogous matters arising out of the same title suit. 34 and 35. Lordship, as for office note dated 21/4/2026, unserved notice has been returned due to insufficient address, your lordship.
You take fresh step
Yes, lordship.
with proper address.
Yes, lordship.
Hard miss.
J. Sharma.
J. Sharma, learned counsel for the petitioner. Office note dated 21st of April 2026 indicates that unserved notice issued to the respondent return with a report insufficient address RTS. The learned counsel for the petitioner submits that she may be allowed to take decisive upon the respondent by obtaining necessary instruction in respect of the correct address of the respondent. Parallel, step be taken by speed post and also by usual process within a week from today after obtaining necessary instruction in respect of the necessary instruction in respect of the correct address of the respondent. List Dr. 4 weeks.
Lordship, there is an interim.
Interim order pass earlier shall continue. In both the matter, there is interim.
Lordship, they are arising out of the same title suit. The proceedings of the title suit was stayed as per order dated 18/3/2026. Obliged, Lordship.
Item 36.
Made to your lordship, as per the office note dated, service upon respondents are completed in the usual process, but in the speed post, AD card has not returned back.
Heard, Mr.
RK Mohanto.
Learned counsel for the petitioner. Office note dated 21st of April 2026 indicates that neither AD card nor unserved notice issued to the respondent number 1 to 5 returned till date. However, the said office note also indicates that notice issued to the aforementioned respondent pro usual process, as per process server's report indicates that notice issued to the respondent number 2, 4, and 5 were received by the brother of the respondent, as the respondents were not present at that time, and respondent number 1 and 3 received the notice themselves. In view of the office note dated 21/4/2026, service upon the respondents, all the respondents deemed to have been completed. In view of above, it is provided that registrar shall list the matter after a week for admission.
Lordship, there is the interim order.
Interim order pass earlier shall contain.
Obliged.
May it please your lordship, as per office note dated 22/4/26, service is awaited in this matter also.
Heard, Miss
S. Sharma.
S. Sharma, learned counsel for the petitioner. Office note dated 22nd of April 2026 indicates that neither AD card nor unserved notice have been received by the section till date. In respect of the respondent number 1 to 3. When you have taken a step,
Lordship, on 31st March 26.
list the matter after 1 week, awaiting service report upon the respondents.
Obliged.
38.
May please your lordship. Lordship, the instant I is for listing of the regular 2nd April for early hearing, your lordship.
Heard, Mr.
J.K. Roy.
J.K. Roy, learned counsel for the applicant, and also heard Ms. Murtaza, learned counsel for all the respondents.
Yes.
And Ms. Kolita for respondent number 23 and 24. And 22, sub-register. 22, 23, 24. This application is preferred by the applicant for early hearing of RSA number 21 of 2021. Any objection? The learned counsel for the respondent submits that they have no objection. Accordingly, it is provided that RSSL list the RSA number so and so for hearing on. In terms of above, this IA stands closed.
Item 39.
Deeply understood.
May I please, Your Lordship? Your Lordship, with a delay condonation application for delay of 33 days, Your Lordship, for preferring the regular second appeal. Your Lordship.
Third, Mr.
R.A. Mazumdar.
Learned counsel for the applicant. This application under Section 5 of the Limitation Act 1963 is preferred by the applicant for condonation of delay of 33 days in preferring the appeal by the applicant. Preferring the connected RSA.
Yes, Your Lordship.
RSA by the applicant against the judgment and decree dated
1/8/25. 1/8/2025.
1/8/2025 passed in title appeal number 8 of 2024 by the learned civil judge, senior division, Hailakandi. Let notice be issued to the opposite parties, returnable in 4 weeks, that be taken by speed post and also by usual process, which will come to the list of the 4 weeks.
Obliged.
Number 42.
May it please your lordship. Lordship, this is a transfer petition wherein I was given an interim order while order dated 24/7/2024, wherein the title suit was stayed. Lordship, the respondents are appearing for the first time in the case.
It's regarding transferring the case from Bishwanath district to Nova. That's the plea. Let us talk together if it can be in a midway, say in Sonitpur, in Tezpur or something.
Lordship,
Maybe in the next day, we'll come up with something.
Lordship, after 2 weeks, it may be listed and
Yes,
in the interim order may be continued till then.
Okay.
After 2 weeks.
Third, Mr.
A. Tarafdar, Lordship, appearing on behalf of S. Nawaz.
Learned counsel appearing on behalf of Mr. S. Nawaz, learned counsel for the petitioner, and Mr. B. Gogoi, learned counsel for the respondent. Mr. Gogoi submits that the matter may be listed after 1 week or 2 weeks.
2 weeks.
2 weeks. So as to enable him to apply instruction as to whether the matter can be settled amicably. List after 2 weeks.
I'm deeply obliged, Lordship.
43.
May I please, your lordship? Milord, in this matter, Milord, this matter listed before the day before yesterday, Milord. And yesterday, Milord, in the execution code, we made an application, Milord. Our application was rejected, Milord. Therefore, since no stay order is there, therefore, the application not considered, Milord. Execution code order I will to place before the court. And this is the order, Milord. And here, Milord, we are the principal defendant, Milord. And Lordship will find out.
This appeal is yet to be admitted.
Yet to be admitted, Milord. And so, principal respondent appeared, Milord, then respondent already, Milord, issued notice, Milord, in this matter. And respondents, Milord, their name may be struck out, Milord. We are not concerned, Milord. We are concerned, Milord, since execution case proceeding, police, even police report in the process for they have initiated, Milord. Since no stay in this matter. So no stay, therefore, our application rejected by the executing court, Milord.
No, why this matter is listed today in the?
Maybe for yesterday in the admission hearing listed, my lord. Today listed for order, supposed to be listed for admission hearing, my lord. But executing court order with your lordship, on last occasion, my lord, the other side has without informing short time. So we mentioned it yesterday, that this honorable court fixed it matter for today, my lord. Supposed to be listed for admission hearing, to listed for orders, my lord. Whereas, my lord, executing court order, this is very important, my lord, to place for stay, my lord.
Next date is fixed on 13/5.
13/5, 13 May, my lord. Already there a police report is directed, my lord. Executing court order kindly may be Paris, my lord.
Heard Mr. Decker, learned counsel for the learned counsel for the appellant. None appears for the respondent. Though one counsel who appeared,
My lord, focus here. Focus.
though one counsel, namely B.
DJ Haloy, my lord.
entered appearance on behalf
Yes,
of
Hussein.
DJ Haloy. DJ Haloy. Mr. Decker, learned counsel for the appellant, submits that all the respondents
Yes, except one, my lord. All the performer respondents.
that the name of performer respondents may be struck off from the array of this appeal. Accordingly, taking note of the submission of Mr. Decker, learned counsel for the appellant, the name of performer respondent number
17, my lord.
2217 be struck off from the array of this appeal at the cost and risk of the appellant. Appellant raises at least the matter on Monday. Next Monday,
No, Tuesday, my lord.
Tuesday,
Tuesday.
for hearing under order 41,
Rule
2.
2, sorry. 2. My lord, already, my lord, police, there's the execution court, my lord, they have initiated the police for
After,
execution.
after admission, we will consider, not now.
But if it is police come with the and evicted from a land, my lord, so
You
till
can-
Tuesday, my lord, for some execution court process till Tuesday, my lord. After lordship,
No. Appeal is yet to be admitted.
yes, that is, but this is
Then-
just urgency, my lord. I can understand. Tuesday, my lord. Okay, yes. Obliged.
For admission, number 11.
Please, Your Lordship, today only we have filed our Bakaratnama. And moreover, as per the instruction of the client, the matter may be for mediation.
No, this is transfer petition.
It's a transfer petition, Lordship.
Yes, sir.
So main matter may be referred to the mediation,
But and it's that
where the case is pending.
The case is pending before the learned court of Kachar, family court Kachar.
Family court Kasar.
Kachar, and we want to transfer it from Kachar to Kamrup Metro.
Kamrup
As,
Metro.
as she is living with her parents, Lordship, as the petitioner is living with her parents.
The instruction is given by the husband itself.
Pardon?
Instruction is given by the husband. They want to, I think, mutually
Settle the matter. Oh, this is transfer petition. This matter, the main matter may be referred to the mediation, but we cannot direct here.
Lordship, this matter has been pending since 2024. On the previous occasions also, they sought time for filing affidavit in opposition, Lordship.
could not file because you did not receive that Wakalat Kama, that's why. Could not.
Today you have received the Ukalatnama.
Yes, okay. Already filed it.
Ukalatnama you have filed.
Yes, sir.
An objection?
No question. Today only we have filed and the instruction given by the husband is that they want to mutually settle the matter, therefore mediation.
Lordship, this matter may be transferred to Kamrup Metro, then we can go for mediation as your Lordship.
Yes.
As suggested.
Or it can be before that court also, Kasar also.
Lordship, in Kachar, we are having difficulty because Lordship, the grounds which we have taken, Lordship, in our petition, my father is a retired person, Lordship, and I had to go with my family members then if we sit for mediation, and distance is too long, Lordship, from Kamrup Metro to Kachar. Then if mediation process takes place there, Lordship, then the suit will proceed there only, Lordship. The main title suit, which the respondent has filed before the Kachar.
Okay, you file your objection, we'll see.
Let them file their affidavit in opposition, Lordship.
Heard, Mr.
S. Paul,
S. Paul, learned counsel for the
petitioner.
petitioner, and Miss
S. Chandra on behalf of S.C. Vishwas.
S. Sanda, learned counsel, appearing on behalf of Mr. S. Vishwas, learned conducting counsel for the respondent. Ms. Sanda submits that she has filed Ukalatnama today, and she applies for granting her some time to file the objection petition. Pair allowed, places allege the matter, fixed date.
Lordship,
Short-
there is an interim order, Lordship.
Okay, interim order pass earlier shall continue.
Right.
6 of May.
Much obliged.
Receive the speaking order, Your Lordship. Just a few minutes ago, Your Lordship. The order is Your Lordship.
So when this order was passed?
Today.
Today. Today. So wait for some time then.
Sometimes.
What was the order passed on earlier date?
On the last day.
18/12.
Yes, 18th. For outcome of the hearing.
Heard Mr. M. Khan, learned counsel for the petitioner. Ms. Terang P, learned standing counsel for the respondent in Secondary Education Department. Ms. Terang P has produced one order number E dash 59927 stroke 62 dated 24/4/2026 and submits that the department in compliance to the order of this court will move the matter by next 7 days to the finance department for according its view for concurrence to the retention of the post to enable the department to take further steps. And Ms. Trengpi further prays for granting her some time to place the compliance report before this court. They are allowed to place the matter on. What is the matter, Han?
Any date lordship after two.
No. What is the matter here?
Matter relating to selection and appointment of grade 4 employee. 2-person, 3-person also is selected. Serial number in merit basis lordship 2 and 3 have already been appointed. And these petitioners has not been appointed because of lack of retention of the post. Now they are going to grant retention.
Okay. List the matter on. Last part of May. 25th May. The order produced before the court shall be marked as Annexure 1.
My lord, my friend may be directed to sub me a copy of that order. Lord.
Annexure 1 and be take to the record. A copy of the order be served to the learned counsel for the petitioner free of cost. Part is a copy too.
Item 13.
Maybe the lordship, pass over for the day lordship. Next to candidate lordship, senior is personal difficulties.
As agreed by learned advocates of both the parties, recess and list the matter
Next to candidate.
after a week.
Sorry, item 15.
16. 16.
15 minutes with time. Petition, we have filed our objection that is not required. 80 days the next.
What is your objection?
My here only question is the inconvenience. It is from the.
Only question?
Inconvenience from Hailakandi to Chitsa.
My lord, husband is coming regularly in to attend a DB case at Silchar. I am from Silchar. I have no means to survive. I have got my old father and one son.
End of 2026, stands dispose of on withdrawal.
Thanks for hearing under order 41. Item 18.
My please, lordship. Appellants or defendants before the trial court. Suit was decreed. An appeal was filed, but there was a delay. So it was accompanied with the application for under Section 5 of the Limitation Act. That has been rejected. So effect is dismissal of the appeal. That's why the second appeal. The order passed in the application under Section 5 of the Limitation Act is page 81.
Page number?
Page 81. Learned,
81 is the order.
order. Now judgment of the trial court is lost.
No, where is your application?
Application, yes. My application section of page 68.
68.
60.
Then what is the ground you have taken there?
Ground lordship, some If I may read, Lordship, this paragraph
No,
one,
not the entire petition, where you have mentioned the ground, the relevant paragraph.
paragraph 4 onwards, Lordship, 4
onwards.
onwards. That very unfortunately, since July 2018, the defendant has certain family disputes, ailments, and other associated unavoidable family problems, and they were not able to attend the court on regular basis. Their engaged lawyer also assured them that he would inform them about the case status as and when required. Thereafter, the case proceeded as per law, and the plaintiff side adduced evidence, and the PWs were to be cross-examined. The engaged lawyer, without intimating anything to the defendants, might have taken subsequent adjournments, and hence by order dated 27/9/2018, the defendants were directed to deposit rupees 2,000 on 1/11/2018 as cost for cross-examination of plaintiff's evidence. This part of the case was also not intimated to the defendant side by their engaged counsel, as a result of which the defendant side were debarred of cross-examination of the plaintiff's witness, and the evidence of the plaintiff side was closed unchallenged. That thereafter, the defendant also lost opportunity to file their witness, as they did not know about the same. The defendants, who were ignorant poor villagers residing in tea garden vicinity, have no knowledge about legal provisions, and they were confidently waiting for response from their engaged lawyer. That in the meantime, the appellant defendant number 1, namely Ram Bachan Roy, who used to look after the case and take steps as and when directed by his engaged lawyer, fell seriously ill as he was suffering from viral hepatitis and was advised rest by the doctor of Lakhipur PSC in the last part of year 2019. Thereafter, there was outbreak of COVID-19 pandemic, and movements of people were restricted. The courts were also functioning in a staggered manner.
No, whether this COVID period was excluded from this 988 days?
No, it is not excluded. It is included there. It is included there.
No, no.
Now,
There is a direction of the Supreme Court to exclude.
Yes, it has to be excluded. This from 15th to 2020 to 28 to 2022. This part has to be excluded. This is also there, included there.
No, no. Are you sure that that part has been excluded? That period has been excluded?
No, Lordship. Judgment was passed in September 2019. It is there is a problem also. Judgment was passed in September 2019. So appeal is 30 days there. And COVID, it was started in December 2019, and Honorable Supreme Court exempted the period from 15/3/2020 to 28/2/2020. So before that, that part was exemption was, but fact remains that this long period also passed for this COVID pandemic.
And how this delay part has been taken care of by the learned court below in the impugned order?
Learned First Appellate Court, paragraph 83, Lordship. Sorry, page 83. Fourth paragraph, on perusal of the case record. It appears that although the petitioners have cast aspersion upon their counsel, Sri Sanjay Thakur, for not conducting their case properly, but the order sheets of the title suit suggest the contrary. It appears that in spite of several opportunities, the petitioner failed to cross-examine the plaintiff's witness and adduce their evidence, due to which the suit was decreed in favor of the opposite party. It also appears that although the suit was decreed in the year 2019, but they filed the appeal in the year 2022, blaming their lawyer for the fate of their case and playing victim card, stating themselves to be ignorant poor villagers having no knowledge about legal provisions. As the petitioners were not vigilant in conducting their case, which can be clearly, so it has been rejected, Lordship. There was.
So how this finding is illegal or arbitrary?
Lordship, this period of COVID-19, as Lordship has referred, this was supposed to be considered, because there is a delay, no doubt.
period is 1 month. Judgment was passed on 21/9/2019. The appeal was supposed to be preferred within October 2019. It was not filed, but learned appellate court, while this considering this petition, should not have gone to the merit of the case. Now, this is the merit of the case that is
No. In condonation petition, delay condonation petition, the court is not supposed to go into the merit of the
merit of
appeal.
Yes.
Hmm?
Now he has gone to the
Where?
records of the
Where?
case also.
Where?
Lordship,
In which part of the order?
no, on perusal of the case record, it
Yes,
appears that
case record does not mean that the appellate court record.
no, but the order sheets of the title suit.
Hmm.
But the order sheet of the title suit number 157 of 2011 suggests that suggests contrary. It appears that in spite of several opportunities, petitioners failed to cross-examine the plaintiffs. Now, this is the judgment has been passed. We failed to cross-examine, judgment has been passed, decree has been passed. Now we have preferred appeal. Ground is that we are not aware of the judgment because learned counsel did not intimate.
Whether you have filed any complaint against that counsel?
That is perhaps
Not there.
Not here. It's perhaps not here.
Not there. Then how do you justify that there is fault on the part of the counsel?
There is that is difficult to prove here, but it is the ground in the
No, Mr. Professor, you see, this is second appeal.
Lordship.
We have to strictly consider the substantial question of law.
There
Here,
is-
equity has no place.
Yes, Lordship. There is another aspect, Lordship. Now, what this the judgment of the trial court has been confirmed due to disposal of. It has been confirmed. So we also need to see the judgment of the trial court. One way of looking that on the delay condonation part, and another when the judgment is confirmed by dismissal of this appeal, we also need to look into the judgment of the trial court, Lordship. And their Lordship judgment of the trial court, if I may, or Lordship at 2, it is already 1:15. And I propose substantial question of 2 substantial question law only on this point. One is on this delay part, another is regarding the at page 6, Lordship, I propose the substantial question of law. Trial court in his judgment at page, while discussing issue number 6, taken contrary view. One way said that there is no pleading of the plaintiff regarding that they are possession of the suit land since 100 years.
That cannot be a substantial question of law here.
Not the perversity, Lordship. If this is perverse,
No.
perversity is a substantial question of
No.
law.
This second appeal is only against the rejection of your application for condonation of delay.
That is, Lordship, that's why Lordship. It's a 3-judge bench. Lordship, paragraph 9. Correct. Another 4 judges decision was also referred. In second part.
No, you say the appellate court has not at all considered your appeal.
Yes.
It was dismissed simply because your
Technical ground.
application is dismissed.
Yes. Lordship, may kindly page 5, Lordship. Page 5. In Shadon Singh versus Darwa Konohar was referred. And in that case, it was held. We are therefore of the opinion that where a decision is given on the merits by the trial court and the matter is taken in appeal, and the appeal is dismissed on some preliminary ground, like limitation or default in printing, it must be held as such dismissal when it confirms the decision of the trial court on the merits itself amounts to the appeal being heard and finally decided on the merits, whatever may be the ground of dismissal of the appeal. If that be so, Lordship, so it is not, the second appeal cannot be limited to the limitation part only. On merit also, it has to be seen. Otherwise, on limitation ground, it will, if it is admitted, it will remain pending for years. So everything will be frustrated. Earlier, there was a decision by Ratan Singh in Ratan Singh case that has been overruled by this decision. In Ratan Singh case, it was held that it is not a decision in appeal.
You produce the decision of the Ratan Singh, we will see.
Ratan Singh is paragraph 12, it has been discussed.
Hmm.
Paragraph 12. Here it says, learned counsel placed reliance on the decision in Ratan Singh versus Vijay Singh and others, rendered by 2 learned judges of this court, and pointed out that it was held therein that dismissal of an application for condemnation at delay would not amount to a decree, and therefore dismissal on appeal as time barred was also not a decree. The decision was rendered in the context of Article 136 of the Limitation Act 1963, and in the light of the departure made from the previous position obtaining under Article 182 of the Limitation Act 1908. But we must point out with respect that the decisions of this court in Messrs. Melaram and Sons and Shaudan Singh Supra were not brought to the notice of their lordships. The principle laid down by the 3 judges bench of this court in Messrs. Melaram and Sons Supra and that stated in Shaudan Singh Supra was thus not noticed, and the view expressed by the 2-judge bench cannot be accepted as laying down the correct law in the question. Of course, their lordships have stated that they were aware of some decisions of the High Courts. I have taken the view that even rejecting an appeal on the ground that it was presented out of time as a decree within the definition of a decree obtaining in the code. Thereafter, noticing the decision of the Calcutta High Court, above referred to the lordships in conclusions apparently agree with the decision of the Calcutta High Court. Though the decision of the Privy Council in Nagendranath De versus Suresh Chandra De Supra was referred to, it was not applied on the ground that it was based on Article 182 of the Limitation Act 1908, and there was a departure in the legal position in view of Article 136 of the Limitation Act 1963. But with respect, we must point out that decision really conflicts with the ratio of the decision in Messrs. Melaram, Sons and Shadon Singh Supra, and another decision of this court read by two learned judges in Rani Chaudhuri versus Lieutenant Colonel Surajit Chaudhuri in SR Constructions versus NP Ramareddy brought to our notice, two other languages of dispute left open the question. Hence, reliance based on that decision is not available to the appellant. So in that manner, it has been discarded. In case same problem what happened to me also. I filed an earlier one case filed an second appeal lawsuit. Registry took objections that is not maintainable. Took the matter to the registered judicial, but nothing happened. Then I had to withdraw. I filed revision with a delay condonation application. Now, when the matter came again before Justice Devashish Borua, so he raised the point, and well, yes, a second appeal has to be filed. So
No, that is well settled.
that is the point. Now,
But the question is, this has to be seen.
which part? Limitation or merit?
No, this second substantial question of law suggested
Yes,
by.
yes, it has to be seen.
So first one is all right.
Yes. Now, there is a point lordship. If I take a lordship to that issue, then I can explain lordship why.
Which one?
That's regarding second substantial question of law. Add two lordship, otherwise.
How many matters are there? You learn.
Or another date may fix. I do not have an objection. Another date may fix or otherwise. Because law is settled that decree for possession cannot be granted on the weakness of the defense. That they did not.
No, we are not concerned with that. The question is, can we frame the second substantial question of law here?
Yes, on the judgment, trial court
Yes.
judgment.
Because in fact, the first appellate court has not gone into the record.
That's why Shevdon Singh I have referred to. That's why. Because the question of merger is also there. Trial court judgment is confirmed in other manner.
Okay, we reserve the order. Heard Mr. Professor, learned counsel for the appellant. Order reserved.
Obliged. The second appeal, my lord, your also see the judgment of the district judge, my lord, at page 40. 2 PM court is not sitting.
Okay, then at 2 PM. Let the council come.
Judgment of the district judge, which starts at page 14. I shall come to the discussions, my lord, at page 19. Para 6. On perusal of Exhibit 1, the agreement for sale exhibited in title suit number so and so reveals that the boundary described in the schedule is, it is mentioned that in the southern side, there is sold out land of Safikuddin and Mubarak. In between, there is government land, including government land. The land of 3 Katha, 12 Chatak was agreed to be sold by Exhibit 1. Exhibit 1 nor specified the actual area of the Patta land and the government land, but only says 3 Kathas, 12 Chatak, including government land. This is perverse actually. So apparently the sale agreement included a portion of the government land. Well, this is absolutely perverse, my lord. I shall come to that. But the plaintiff the plaintiff suppressed the presence of the government land in the southern side and only mentioned about the sold out land subsequently in Mubarak Ali. While the perusal records that the judgment decree prepared not on the basis of the boundary of the Exhibit 1 sale agreement, but on the basis of the boundary mentioned in the plaint of the plaintiffs. Until unless it is determined as to how much patta land and how much government was government land within the boundary given in Exhibit 1, it cannot be said that decree was executed properly. The government was not made party in the title suit number so and so, and decree was obtained over a portion of the land described in Exhibit 1, which is included government land. Well, this is wrong, madam, because the original owner, well, he purchased a land, that sale deed was produced in the trial court when the decree was passed. Now, in course of hearing, learned counsel appearing for a respondent submitted that when the appellant decree holder could not occupy the government land, he illegally constitutionally occupied the land of the respondent in the same patta. Detailed on cross-examination admitted that the land, so I'm skipping over, madam. Now your losses may turn to next page, para 10. From perusal of the impugned judgment and order, was the learned trial court, it appears that learned trial court took into consideration the boundaries of two cell deeds, arrived at a conclusion that there is a boundaries of both cell deeds are different. And as DW1 stated that he has no objection. If the petitioner is granted relief paid for the impugned judgment and order, so and so and so. But from examination of the materials on record, the root cause of the entire matter lies on in the fact that the decree in title suit was passed including government land, which is clearly mentioned in Exhibit 1, and total suppression of fact in the schedule of the plaint, so and so that the said land measuring so and so government land. Therefore, it established that appellant's purchased land included government land. Plaintiff title suit number so and so in miscellaneous appeal firstly did not disclose actual area of patta and the specific area of the government land within the total land of 3 kata 12 chatak land described in Exhibit 1. Secondly, from perusal of the plaint in title suit number so and so, it appeared the plaintiff appellant stated as follows in paragraph 2. The defendant, the owner of the land described in the schedule below by right of purchase, and the defendant purchased the land from Muhammad Maskandar Ali Laskar, son of so and so, Silchar, through registered deed by deed number so and so, and the office of the deputy commissioner register Silchar on payment of valuable consideration of government possession of land. So defendant Samal Dhar had purchased the land by registered sale deed number so and so. This deed was never produced by the plaintiff appellant during the trial, which contained the description of the land purchased by the Samal Dhar. Well, this is absolutely wrong, my lord. That was exhibited, my lord, there in the trial court, my lord, original suit, my lord. The plaintiff again, my lord, so and so, the said land was purchased by defendant Samal Dhar from Maskandar Ali, it was sold by Samal Dhar. Accordingly, agreement for sale was executed on between Samal Dhar. In course of trial, title suit number so and so, Samal Dhar did not cross-examine.
No,
My
Mr.
lord.
Sahayullah.
Yes.
This appeal is registered as a second appeal.
Yes.
In second appeal, you have to suggest the substantial
That is
question. of
perversity,
law.
my lord. Perversity is the main question. I can show, my lord, the perversity is the question which is
No,
substantial question of law.
no, that's all right.
Huh.
But where you have suggested the substantial question of law here?
My lord, yes. Yeah, my lord, your lord, see, whether the judgment of learned appellate court below is perverse to the facts of the case, which holding that agreement for sale reveals the boundary of the scheduled land includes government land, whereas east of the land there is embankment and national highway on the west, and there is only government land. Well, government land is beyond that. For that, they are finding out perverse as the land purchased by the Samal Dhar from Maskandar Ali, petitioner interest of the vendor, which is 3 kata 12 bacha of dark number so and so, registration operation, and the same was agreed to be sold to the appellant by the agreement for sale. An eastern boundary of the land is ED embankment and thereafter a Mocklin drain, whereas as per boundary, the respondent ED embankment and the drain on the east, and as such the same cannot exist. They are without encroaching the land of the appellant, and this fact was failed to be considered by the respondent. Now, my lord, learned appellate court says that they have not produced the sale deed of Samal Dhar. My lord, he could have called for from the trial court record, my lord. And I shall produce, my lord, if you also see the sale deed, my lord. My lord, this is the sale deed of 88, my lord. Your lordship may just see, my lord. the schedule presented. তফসিল চতুসীমা জেলা কাছাড় শিলচর থানা শিলচর সব রেজিস্ট্রি অফিসের এলাকাধীন পরগনা বরাকপাড় মৌজা 29 নম্বর পাট্টার 198 ডাক জরিপাতে 600 ডাক মধ্যে 3 কাঠা 12 ছটাক ভূমি জমা সার পূর্বে 600 দাগে পশ্চিমে বাইপাস রোড এই দাগে অবশিষ্ট উত্তরের ডিসি কলেজ আশ্রম রোড এন্ড দক্ষিণে শরীফউদ্দিন সবারকালী ভূমি তন্মধ্যে this is 3 কাঠা 12 চার ভূমি বটে। Well, this is the land. Now, they have, if you also see, they have shown my lord why this difficulty arose. If they purchase from the legal heirs of the my lord purchaser. Legal heirs of Maskundar Ali Laskar. So legal heirs of Maskundar Ali Laskar, my lord, if he has any separate land, they can sell it. My lord, in the boundary what they have shown, if your losses comes to page 12 of the memo of appeal. My lord, page 12 of appeal, my lord, this is trial court judgment. They have exhibit one held it pertains to the petitioner purchasing 2 kata 8 sadak land with the boundaries. East is same, my lord. West they have shown Shyamaldhar's land sold. Shyamaldhar's land sold means to us. So let them execute their own land, not in our land. Well, that is the main question. The learned appellate court below wrongly said that our land included government land. That is perverse. There is no government land, my lord. In the boundary, beyond that, my lord, government land is there. That is, my lord, my lord, virtually, my lord. There is a mistake committed by the appellate court below. Now, this where this Shyamaldhar's land sold, it means our land is different. He said, as per them. Whereas not same road, Satsang Assam road, same, DC Assam road. In our boundary, my lord, your losses are seen. Next one. West bypass road and its meaning dark. So this confusion occurs, my lord. He could have seen the original cell deed of Shyamaldhar, my lord. Shyamaldhar cell deed is absolutely clear. There is no question of government land inside the my land, my lord. The boundary beyond the mother, there, if any government land is there, that has nothing to do with them. That is a perversity, my lord. Justice is to be done, my lord. They cannot, my lord, the appellate court cannot in this way, my lord, but at least said that, no, this is not so.
No, in
My lord,
page number 10
yes,
of the impugned order,
yes,
at paragraph number 17,
I'm correct.
the description of boundary is given.
Yes. My lord. That is the, my lord, mistake committed, because that is why I saw your lordship, my lord, page 12. They, both the boundaries has been given. Now, can it be find out, my lord, this their land without my land? Their land they have shown West Chamaldhar's land sold. It means it is sold to us, Chamaldhar land. Can it be found, my lord? Appellate court should have, my lord, seen that. Our land is very clear, my lord. We have purchased the land and they have purchased from the legal heirs of our original vendor. Whether they have more land or not, that is also to be seen. Actually, by this order, my lord, the appellate court has set aside our decree, passed in our title suit, my lord, which was passed after consideration of all the exhibits. I've also given a copy of the Chamal's horse self, my lord, to my land friend. This can be compared, my lord. The appellate would say that that was not filed, but he could have called it from the record. Or he could have directed us also to submit it. There is no government land, my lord, within us, our land. Only the confusion occurs, my lord, because of their boundary. They have shown that West Chamal's horse land sold. It cannot be find out, my lord, their land. If they find out, my lord, they let them do without touching our land. They wanted to occupy our land, my lord. We purchased it from the procedural interest of their vendors.
So this appellate court has affirmed the finding recorded by the trial court.
Yes. But Malad trial court actually has Malad gone that it is separate land. Malad, from the boundary given, it appears so, my lord. But now they wanted to occupy our land. That is the main question, my lord. They have to find out, my lord, if there is any other land, my lord. To their, So that is the main question. And appellate court has committed wrong also, saying that it includes government land. My lord, if you also see the boundary given by the appellate court, page 22, it is not, my lord, inside the boundary government land is there, page 22. 23, actually, 23. South sold out land to Substitution and Mubarak Ali, which includes government khas land. Well, that is there, my lord, Mubarak Ali and Substitution, not ours. And our land is 3 kata 12 bicha.
Okay.
So government land is not inside our land. And that is why I produced the shown the salary in favor of Shamaldhar.
Okay, Mr. Mazumdar?
The case and show my lord, it may not be admitted. My lord, two persons executed an agreement to sell without giving any boundary. And there was no contest from the defendant. He filed written statement, but he did not admit any evidence. Decree was passed. Decree for specific purpose of contract. While executing that decree, they have dispossessed me. Then I filed an application under Order 21 Rule 97, and I proved that I was in possession of my land. And they have included in their plaint, it's a clear finding of fact by the learned courts, they have in their plaint, without referring to the sale deed of their vendor, my learned friend is giving the sale deed, that was not proved before the learned track, but that is the finding of the court below. The court, it is not duty of the court to ask someone, please bring your certificate copy of the sale deed, I will compare. This is not the duty of the court. Plaintiff has to prove his case. Now, in the clear finding of the London courts below is that in your plaint you have included government land. Now, while and got a decree. Now, while executing the decree, government position cannot be given, so they have entered into my land, took my possession of my land, and then they wanted to hand over, and they have handed over. This is the simple case. Now, I will go to the finding a little later, my lord. Their own admission, they have examined two witnesses. I'm just reading 3 lines from their DW1. And they themselves are admitting that I have got no difficulty in this the Order 21 Rule is decreed because my land is different. Now the argument is that it is forward. Where is the question forward? You have admitted. But you kindly see this DW1 matter. I am just pardon. I just go to the relevant part. Second page of mechanism. DW1. This is DW1, Profulla Chandra. Second page, my lord. Line number 4 from top. Exhibit 1, Roshni's got my lord. Exhibit 1 is my sale deed. Exhibit 1 is the sale deed by which sellers, Rabia Begum Laskar, my vendor, my lord, and others sold 2 kata 8 chatak. My land is 2 kata 8 chatak. 2 kata 8 chatak land in favor of the petitioners, Girindra Das, my client, my lord, covered by so. It is mentioned in Exhibit 1 that the sellers are the legal heirs and successors of Muhammad Maskandar Ali Laskar. Say 2 kata 8 chataks of land mentioned in Exhibit 1 is bounded by east ENT Ban, Nala, west sold out land of Shamaldar, north Satsang Ashram Road, and south sold out land of Niranjan Ghosh. Now this is important. The sold out land of Shamaldar is situated in the western side of the 2 kata 8 chataks of land. So it is the admission of DW1 that sold out land of Shamaldar is in the western side of 2 kata 8 chataks of land which I purchased. Furthermore, the 4 boundaries of the decretal land in connection with tax number so of this code are as follows. Boundaries given. Now, therefore, can you see the decretal land of title suit number 59 of 2008 is situated within the above 4 boundaries. The land of the petitioner, as mentioned in Schedule 1 of this dismissed case, and the decretal land, as mentioned in Schedule 2 of this dismissed case, are distinct and separate. You have got a decree in a separate land, I am in a different land. Their admission matter. I have no objection in the petitioners getting the decree as paid for in respect of Schedule 1 land of this case. They have admitted matter. It is in the cross-examination TW1. They are witness, number 1. He admits, my lord, the land is different and distinct. And if your land is given to you in this proceeding, I would know this. And that is why, my lord, Lordship will find in the memo of appeal, I'm just showing, my lord, page 20, my lord, in the order of the appellate court, my lord, page 20. Clear case, my lord. deliberately, my lord, by showing, suit was filed by showing, including the government land. Now, while delivering possession, government land cannot be delivered, so they have taken away my land. This is the finding of the court, my lord. And I have been dispossessed. I'm very poor man, my lord, small petty shop, some shop was there. I have put one tenant, he is running a very small shop, he has been dispossessed. And he had to now run from pillar to post, file suit, this case, that case, bring every witness. Lordship, may kindly see page 20, para 7. So apparently this is the finding of the land appellate court, my lord. So apparently sale agreement exhibit 1 included a portion of government land, but in the plaint of title suit number so and so, plaintiff suppressed the presence of government land in the southern side and only mentioned about sold out land of Sabikuddin and Mubarak Ali. Suppression is a finding of fact. Perusal of record reveals that judgment and decree was prepared not on the basis of boundary of exhibit 1, that is the sale agreement, but on the basis of boundary mentioned in the plaint by the plaintiffs. Until and unless it is determined as to how much was patta land and how much was government land within the boundary given in exhibit 1, it cannot be said that the decree was executed properly. The government was not made a party in the title suit number so and so, but decree was obtained over a portion of land described in exhibit 1, which included government land. They're all finding of fact, my lord. In the course of hearing, learned counsel appearing for the respondent submitted that when the appellant decree holder could not occupy the government land, he illegally and coercively occupied the land of in the same patta. What else can be done, my lord? It's a clear finding. DW1 in his cross-examination admitted that the land described in exhibit 1 measuring 3 kata 12 chetaks also includes government land. He admitted that he did not know the total area of government land within 3 chetak 12 chetaks of land of schedule of exhibit 1. DW2 admitted that the decree in title number so and so was passed including a portion of government land. But the sale deed exhibit A was prepared without mentioning about the government land mentioned in exhibit 1. It's a clear case of fraud, my lord, actually. From perusal of the impugned judgment and order passed by the learned trial court, it appears that learned trial court took into consideration of the boundaries of two sale deeds and arrived at a conclusion that as the boundaries of both the sale deeds are different, and as the DW1 stated that he has no objection if the petition is granted the relief prayed for, passed the impugned judgment and order and decree in this case and so. But from the examination of material on record reveals that the root cause of the entire matter lies in the fact that decree in title suit number so and so was passed including government land, which is clearly mentioned in exhibit 1, agreement for sale, and total suppression of fact in the schedule of the plaint of title suit number so and so, that the said land measuring 3 kata 2 cheta included government land. Therefore, it is established that appellants purchased land included government land. Plaintiffs of title suit number so and so in this case number so and so firstly did not disclose the actual area of patta land and the specific area of government land within the total land of 3 kata 12 chetaks, land described in exhibit 1. Secondly, from perusal of plaint of title suit number so and so, it appears that plaintiff appellant stated as follows in paragraph 2 of the plaint. The defendant is the owner of the land described in the schedule below by right of purchase. Defendant purchased the land from one Maskandar Ali Laskar, son of so and so, Silchar town through the registered deed of purchase so and so, the office of the deputy commissioner Silchar on payment of variable consideration and got possession over the same. So the defendant Shamaldar had purchased the land by registered deed number so and so, dated 12/8/1988. This deed was never produced. You are filing a suit for specific performance of contract, and the vendor's sale deed is not produced. How will the court know to what extent he was the owner? The plaintiff appellant again stated in paragraph 3 of the plaint as follows, that while the plaintiffs are possessing their respective monthly bharatias, the defendant approached them to sell out the scheduled land to them, and after negotiation, the concession price of the scheduled land is settled at rupees 9 lakhs. Defendant received 1.55 lakhs only as an advance earnest money out of the total consideration price and executed bindnama in favor of the plaintiff, agreed to execute and register the sale deed on necessary permission within 1 1 year of execution of the party agreement. So the said land which was purchased by defendant Shyamal Dhar from Maskandar Ali was agreed to be sold to the plaintiff by Shyamal Dhar, and accordingly agreement for sale was executed on so in between the plaintiff and appellant. In the course of trial of practice number so the plaintiff Shyamal Dhar did not cross-examine the PWs, and though the defendant Shyamal Dhar had filed written statement, he did not adduce any evidence in the suit, and the decree was passed in the suit uncontested. So it's a clear case of collusive suit matter. While executing the agreement for sale, I will input government land. You take the decree, but while giving the possession, I will take possession from a third person. In the said suit, title suit number so PW1, Gauranga Sarkar adduced his evidence on affidavit and exhibited agreement for sale so marked as Exhibit 1. Now, from perusal of Exhibit 1, it appears that the description of land measuring 3 × 12 sector was given by Shyamal Dhar as follows. But the next paragraph, my lord. But the description of land measuring 3 × 12 sector given in the plain of schedule is as follows. Next paragraph, my lord, we are not examining this description. So it reveals that in the south, there is no mention about the government land in the schedule of the plain. Therefore, Exhibit 1 included government land within the total area of 3 × 12 sector, but the land described in the plain, which was comprised of 3 × 12 sectors, is totally silent about the government land. Therefore, there was a defect in the schedule of the plain of practice number so on the basis of which decree was drawn and subsequent sale deed Exhibit A was prepared. As stated already, the sale deed number so was never produced by the plaintiff. Therefore, the submission made by the land counsel for the appellant so is not acceptable. The land trial court, though, did not discuss the root of the matter, but passed the into judgment in order and decree on the basis of the evidence on record, and after examining the sale deed by which the petitioners of Ms. J.K. had purchased the land measuring 2 × etc. within specific boundaries. My sale deed is not under challenge, my lord. My sale deed with my boundary is not under challenge. If the, my lord, appellant with your lordship was really thinking that my sale deed is bad, I am occupying the land illegally, then he would have challenged it. That he is not challenging. And he has been totally exposed by the landed courts below and by his own witness. So it's a clear case where the finding of fact has been recorded by the landed courts below. And there is absolutely no perversity now. No perversity could be shown. Findings are very clear. And I have shown that they have admitted that if his land is given to him, I have got no objection. Why? This appeal may not be admitted, my lord. And I have been disposed, I am a poor man, I have been disposed from my own land.
Poor man, both are poor men, my lord. Illiterate person, my lord. My lord, here, what happened, my lord? If your lordship will see, they have shown, that is why, my lord, I have shown page 12. They have shown West Shyamal Dhar's land sold. On looking at the on looking at the boundary, what it reveals, my lord. Now they wanted to occupy my land, and moreover, I have produced the Shyamal Dhar's purchased land. Who purchased the land from the original owner, the predecessor in interest of their vendors. After selling them, if any land remains, my lord, because this is to be inquired into. Without inquiry, how they can say that it to be executed? Because on the west Shyamal Dhar land, where is our land? That is to be seen, my lord. And perversity is there in the appellate court's order that it includes government land. That boundary I have shown, my lord. He has mentioned it in the boundary.
What about
in the boundary, my lord, it says sold out land of Safikuddin and Mubarak Ali, which includes government khas land. Mubarak Ali land, my lord, that includes government khas land. But our land is absolutely separate, my lord. How it can be, my lord? And Shyamal Dhar's purchased land, I have shown, my lord. He purchased in 88. They purchased long after, my lord. From their, my lord, subsequent to their sons and daughters. So Shyamal Dhar's land is absolutely clear, my lord, this sell deed. There is no government land, my lord, inside that.
No, that's all right. You see, in second appeal, we cannot reappreciate the facts.
This fact is not, my lord, this is a virtually perversity. He said that government land is there. Government land is not there, my lord. And the boundary I have shown, my lord, that beyond that, my lord, there is government land. Boundary does not mean that, my lord, in the boundary, inside the boundary, there is government land. That is a perversity, my lord, of the appellate court judgment. And how they can execute this, my lord, because virtually appellate court has set aside my decree. Virtually appellate court has set aside my decree.
Appellate court is right.
My lord, how he can,
Under section 96.
no, 96, my lord, he cannot set aside because they have not challenged our decree. They have not challenged our decree. How it can set aside my decree?
My lord, that is absolutely illegal submission. Order 21, rule 97 itself provides that I have to challenge that.
No.
Order 21,
My
rule
lord,
97 is
order
a suit.
21, rule 90, my lord,
It is a suit.
says that,
I have been disposed, my lord.
yes,
My lord, leaving
your
aside
lordship may
everything,
see, I can,
what to do with this?
I can
admission in
produce
the
several
DW
judgments.
cross-examination, my lord.
I
This is
can-
pervert. Can they say that this is also pervert?
I can produce it.
They are admitting that I have disposed to you illegally, and if your land is given back to you, I have got no objection. What else?
My lord, this is the, my lord,
They are arguing against their own case. DW1, are they saying that DW1 is a
my lord, what is order 21, rule 90, my lord, your lordship?
it's a pure and simple
Only thing that they are possessing their land of their own right. If that has been dispossessed, then only they can be restored. This is the, my lord.
I have been disposed.
My lord. My lord, paragraph 5, 9, 11, my lord. My lord, paragraph 9 may be seen. Decree cannot be set aside, my lord. My decree cannot be set aside, but this is only thing, my lord, regarding poison. Para 9. In short, aforesaid statutory provision on the 29, complete court resolving the disputes pertaining to execution of the decree for possession obtained by decree holder and whose attempts to execute the said decree met with tough weather. Once resistance offered by the purported stranger to a decree, which comes to the by executing court as well as decree holder, the remedy available to a decree holder against the obstructionist is only under order 21, rule 97, and he cannot bypass the obstruction issued by warrant of possession under order 21, rule 35 for police force of that course amount to bypassing so and so. So, my lord, then one such obstruction in the court, executing court is difficult to approach. How the executing court can tell the construction that he must possession, then only remedy is to move the application and under order 21, rule 19, pray for restoration of possession. High Court by impugned the order has taken the view that only remedy available to the stranger, the decree who claims to be any independent right, title, interest, decretal property is to get go by order 21, rule 99. This view of the High Court aforesaid statutory scheme is clearly unsustainable. It is to utilize that stranger to a decree who claims independent right, title, interest in the decretal property can offer resistance before getting, actually, my lord, this is before disposition also, my lord. So that is only possession. This is only for possession, my lord. Only for possession, my lord. My lord, here, my lord, independent right, my lord, there. If they have any independent right of possession, then only they can get it. Here it is not so, my lord. Here, actually, appellate court has gone astray. He said that our land includes, my lord. Actually, there he has set aside my decree without looking at the original cell deed, my lord. Justice is done, my lord. My vendor has purchased the land without, my lord, government land, and that land has been sold to me.
No, Mr. Sayola, you see, in cross-examination, it has been admitted that I have no objection.
That
In
correct,
the
my lord. That
petitioner's
is correct.
getting.
That is correct. That is why, my lord. If your lordship page 12, that is why, my lord, that is the illiterate person say that in the boundary it has been shown West Chamaldor's land sold. That is why. Now they wanted to execute in my land. They wanted to take possession of my land. Your lordship may direct the, in that case, my lord, to revenue authority to verify the land.
And a party has no objection, if the council cannot have any objection. Party itself is saying, I have no objection.
No, that is correct, but they wanted to take my position of my land.
This appeal or the first appeal ought not to have been filed after looking at the admission in the crossing event.
My lord,
He says, my lord, that yes, wrongly we have obtained a decree in respect of your land, and if your land is given back to you, possession is given back to you, and possession is restored, I have no objection.
so land record authority has to verify
Why
both
should
the
they
lands, my lord.
verify?
Without verifying, how they can find it out? Because our, this land was purchased by my vendor in 88. And when they have purchased it, long after, my lord, the subsequent, my lord, sons and daughters of the vendor. They purchased it, my lord, in 2012. This, their boundary itself, my lord, committed, my lord, mistake. These innocent persons, my lord, they not know from the, this boundary, they so find that the different land. But now they wanted to acquire my land. So land revenue authorities have to verify which land is there. My land was purchased long back.
Lord will pass the order.
And moreover, this inclusion of government land is absolutely perversity, my lord. That is why my submission is this, my lord. This second appeal will be admitted on that fact, the perversity, and I shall file the copy of the that sale deed also. And a report may be called for from the, my lord, revenue authorities regarding the both the
Your
lands.
lordship will dismiss the appeal. There is no substantial question flowing out. There is a clear admission. More than this, there cannot be any clear admission. He says that I have included complaint, complaint lender was included, and I have no objection. There cannot be any question of admitting this appeal. There absolutely not. This court is not the advisor of the.
No question of advisor, but
There should be
that
sent to the revenue authority.
sale deed itself shows that there is
You
no
have
government land.
admitted that you have illegally
Huh.
obtained.
And my decree has been set aside by the appellate court below. How they can, exiting court can set aside, go behind the decree, my lord.
Pass the order.
High court can go, the appellate court cannot, executing court cannot go behind the decree, my lord.
Okay. Heard Mr. G. and Sayala, learned senior counsel assisted by Ms.
Yes, sir.
Learned counsel for the appellant, and Mr. B. Mazumdar, learned counsel, learned senior counsel assisted by Mr. Learned counsel for the respondent. Argument concluded. Order is that.
Will be ordered.